Rise for a point of personal privilege, Mr. Speaker.
Gentleman may proceed.
Thank you, Mr. Speaker. I rise today in furtherance of our discussion about Black History Month, and I want to talk for a minute about a little part of Black History Month that relates to my district, and a little part of it that doesn't get as much discussion because it never got as much press. Desegregation came to Fairfax County's public schools back in 1960, but it took a while to fully implement. And in 1964, the League of Women Voters issued a report about Fairfax County and noted that things were moving along just about everywhere except in private swimming pools. And I had a former constituent of mine who was born in 1923. His parents were from County Galway. They were Irish immigrants. They, when they raised him, didn't want to teach him the Irish language. Because of what they had experienced in New York as immigrants. They wanted him to, they didn't teach him a lot about his Irish heritage. He eventually ended up serving in the United States Navy. He used the GI Bill to study linguistics at Georgetown University. One of the languages he learned was Spanish. And because he learned Spanish, he decided to start going to some Latino dances in the D.C. area. Ended up meeting his future wife, a Guatemalan named Flora Lopez Enriquez. The Sullivans married. In 1949, they decided to move to the 44th District, a little neighborhood called Bucknell Manor, which is one of the early neighborhoods in my district. And along with their purchase of their home, also along with that came ownership in a non-stock corporation, today we call it a homeowners association, called the Bucknell Manor Development, and membership came in the Little Hunting Creek pool. About 10 years later, the family decided to purchase another house, and they turned their original house into a rental property. Whenever they leased their house out for $129 a month, they let the family who rent it use the pool membership. And that worked pretty well for a while. Then in 1965, the Sullivans decided to rent their home to a man named Ted Freeman. Ted was an economist at the Department of Agriculture. He had his PhD from the University of Wisconsin. He was married, had a couple kids. The only problem was that the Freemans were black. When the Freemans showed up at the pool didn't like that. And the pool told the Sullivans that the Freemans were not going to be going to the pool. They said it would drive other members of the pool away, make people not show up. This is in 1965. So Mr. Sullivan tried to gather support from his neighbors, because he still lived in the same neighborhood, to try and change this policy. Because of that, Little Hunting Creek Pool terminated his membership. Afterwards, he told the Washington Post that he reacted with absolute and utter confusion. He said, here's a Christian community that talked about decency, fair play, and sportsmanship, and they were treating people like this. So he went out and found a lawyer who would take his case for free, and they filed suit in Fairfax County Circuit Court for $30,000 in damages and reinstatement of their pool memberships, both the Sullivans and the Freemans. They lost when a Fairfax County Circuit Court judge found that the pool was a private club and therefore was exempt from civil rights laws, and they could exclude whoever they wanted to. So they appealed their case to the Supreme Court of Virginia in 1967. The Supreme Court of Virginia threw their case out because they said they didn't make some transcripts available for somebody to look at. So they appealed to the United States Supreme Court. In 1968, the U.S. Supreme Court told the Supreme Court of Virginia, go hear their case. In October 1968, the Supreme Court of Virginia said, we're not going to hear their case. So they had to appeal it again back to the United States Supreme Court. So while all these appeals are going on, this all started in 1965, and this litigation is going on. They continued to receive threats and reactions from their neighbors. The Post interviewed a couple of neighbors. In 1969, one neighbor said, if they let the coloreds in, I'd close the pool down. I'd sell it or close it. They received late-night phone calls. Their mailbox got blown up a couple times. Eventually, Mr. Freeman couldn't take it anymore, and he took his family and they moved. Mr. Sullivan, continuing to try and build support, went to his church, which was right down the street, and asked his pastor to talk to the parishioners about it. his priest refused, said that it wasn't an appropriate thing for a church to talk about. So Mr. Sullivan, disgusted, decided to go join a different church. Went up to St. Joseph in Alexandria, which was a predominantly black church. And from then until the rest of his life, he worshiped there and sang in the gospel choir. The Supreme Court eventually heard his case in 1969. And in that case, the Supreme Court, they were arguing under the fair housing laws that this was a denial of civil rights. And the pool's lawyer argued that they had denied this membership to maintain their economic solvency because the families joining this pool would cause a flood of members to resign. Turning away the Freemans had nothing to do with the fact they were black, the lawyer said. So Thurgood Marshall looked at the man and said, it had nothing to do with that? And the lawyer said, no, it's not race. And so Thurgood Marshall said, well, can I say it's just color then? And laughter rose in the gallery, according to the Washington Post. So on December 15th, 1969, the U.S. Supreme Court decided Sullivan versus Little Hunting Park Incorporated. It was a 5-3 decision signed by William O. Douglas. And in that case, he wrote, Negro citizens, North and South, who saw in the 13th Amendment a promise of freedom, freedom to go and come at pleasure and buy and sell when they please, would be left with a mere paper guarantee if Congress were powerless to assure that a dollar in the hands of a Negro will purchase the same thing as a dollar in the hands of a white man. At the very least, the freedom that Congress is empowered to secure under the 13th Amendment includes the freedom to buy whatever a white man can buy and the right to live wherever a white man can live. Congress cannot say that being a free man means at least this much. Then the 13th Amendment made a promise the nation cannot keep. They went on to hold that this was not a private club. What we have here is a device functionally comparable to a racially restrictive covenant, which the Supreme Court had previously said was no longer allowed. The case was then remanded to the Supreme Court, which sent it back down to Circuit Court. And the Sullivans finally had their day in court where they received a whopping verdict of $5,150. And the judge ordered that their pool membership be reinstated. This is in 1969. In 1970, across the river, a Montgomery County pool decided they were going to deny blacks the right to join. There was a black doctor and his family at a Silver Spring pool. They sued, and in 1973, the Supreme Court again reaffirmed the Sullivan case and ordered Montgomery County, this pool, Montgomery County in Maryland, to open its pools. Ultimately, thousands of pools in the United States were desegregated because of this lawsuit brought by Paul Sullivan out of my district. And for Mr. Sullivan, he and his wife and their family continue to live in my district. He retired in 1980 after 30 years in the Department of Defense. I knocked doors on his street, actually, about 6 months ago. His wife still lives there. His daughters actually live in 2 houses right on the same street. He died on March 14th, 2011, from complications from a stroke just last year, leaving his wife after a 61-year marriage, and he has numerous, obviously, children. I think he had 7 kids and grandchildren. On July 29th of last year, this body passed a memorializing resolution in his honor. The important part is that I wanted to mention, bring this to your attention, is the desegregation of private accommodations and specifically pools began in this state. It also began in the 44th District. And it was because of families like the Sullivans that had the courage to stand up, to put up with their mailboxes being bombed, late-night threats, ostracism from their church, ostracism from their neighbors, in a county like Fairfax County even, that this state and this country changed its ways. I just wanted the body to make the body aware of that. The history of bringing an end to desegregation is a broad one. It encompassed many facets of our lives. It involved a lot of people. And as part of Black History Month, I think we ought to honor the contributions of many people that brought about change in this state. Thank you, Mr. Speaker.